Representative gentleman.
Oh, hell yes. Here's the Fifth Circuit saying that it's unconstitutional.
Good morning, sir. Sir, you're charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Shh. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 5th, 2025, the officer responded to a suspicious person with a weapon on 5900 Gulf Freeway. The officer made contact with the defendant, who was 17 years old. The defendant advised he was inside Jack in the Box while brothers were selling waters outside. The defendant saw a male rushing at his brothers with a knife, pulled out his gun, and pointed it at the male while telling his brothers to run. The officer performed a search on the defendant, locating a 9mm Glock 19, and the defendant advised he bought the gun from a friend for $150.
I mean,
Yes, Judge. In this case, the officer was going off the fact that he performed the search because he indicated there was a firearm. So
he's going to the defense of others.
yes, Judge.
It's another person.
And it's just the way this is pled is because he's underage. He's below the age of 21. That's the way it's pled, Your Honor.
You hear this?
Hold on. I'm going to go yell at somebody. Hold on.
Don't know what's going on.
Hi, Judge. Is this young man charged with unlawful carrying of possession for being under 21?
Correct.
Hold on. I've got a kit. Here's the GPS
But I'm
memo.
more concerned about the defense of others. Did you hear it? I mean,
Well, hold on.
hold on a second.
Here's GPS.
Let me give you a lawyer, Mr.
Yeah. Oh, I volunteer representation. Yeah.
Give me a record, can you fill that out, please?
I will do that. But here's a GPS memo saying that it's
on a second.
unconstitutional.
Representative gentleman.
Oh, hell yes. Here's the Fifth Circuit saying that it's unconstitutional. Here is the United States District Court, Northern District, saying it's unconstitutional. Here's a motion to quash information. I'll just cross out the name.
Great job.
Yeah, I had to get in this fight yesterday, and I'm teed up.
Right here is where things take a dramatic legal turn. Up until this point, the case looked pretty straightforward. Underage possession of a firearm, which is typically a serious charge. But now, the courtroom is shifting focus to something much bigger: constitutionality and the legal doctrine of defense of others. The judge is clearly recognizing that this isn't just about possession, it's about why the weapon was used. The defendant claims he acted to protect his brothers from an immediate threat involving a knife, which could potentially justify his actions under self-defense laws. On top of that, we're hearing references to higher court rulings like the Fifth Circuit, suggesting that the law being used to charge him might not even hold up constitutionally. That's huge. Okay, so now the real question becomes, was this a reckless illegal act or a split-second decision to protect family? What would you have done in that situation?
Here you go, Mr. Tito.
Thank you.
Judge,
I was
is there
gonna,
PC?
yeah, look, you gotta be very careful. God forbid something happens where you really dig yourself a hole. I'm gonna find no probable cause, but really, you have to be very careful. Sometimes you make a decision in life and it can really have consequences, all right? You know what that means, right? Are you in school? It all starts with school, man. You got to get back into school. This is not a good way to go through life. The more schooling you have, the more money you're going to make. Knowledge is power, my friend. Do it. Make something. Make me proud. Please. It's going to get dismissed. Be careful, friend.
Yeah. Literally have all that on because I have a case in another court.
I was going to find no PC anyways. So.
Brandon?
Did we get Cerna?
Yes.
Do you know?
No, Judge.
Perhaps Monday, maybe. I'd like to look him up. We'll look him up. You were Mr. Deshawn?
This case starts like a routine reckless driving charge. But don't be fooled. What looks like a straightforward traffic violation quickly turns into a deeper breakdown of how weak evidence can unravel an entire case. We've got a defendant facing jail time, a judge who isn't convinced, and a key moment where everything hinges on what was actually seen versus what was written. The question is, was this truly reckless driving or just an overcharged situation? Stay locked in, because what happens next might completely flip your expectations.
So you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Your Honor, I apologize. Maybe sure.
Deshaun is DES.
Your Honor, on March 27, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle make an improper turn, nearly causing an accident with the vehicle turning next to him by turning into the wrong lane. The defendant then traveled 88 miles per hour in a 50-mile-an-hour zone and made an unsafe lane change while speeding.
What? That's it?
Yes, Your Honor. The information, the charging instrument alleges that
Oh.
the reckless driving is based on a willful and wanton disregard for the safety of persons by driving more than 35 miles over the posted speed.
To this, I'm going to take more time with yours. Just take a seat for me in the jury box so we don't forget about you, Mr. Deshaun. I'm not ready to make a ruling on this yet. Grab your stuff. Just hang tight with me. Can you point him something real quick?
Yes.
Yeah.
Page 5.
Mr. Raymond. Reckless driving, Judge Reed. Do you want him up?
No. I had a bit of an issue with this. That's why I wanted to appoint him someone to see. Go to the left. Out of view. There we go. Okay, perfect. Okay, so can you read me the DIMS again, Alex?
Yes, Your Honor. So on March 27th, 2025 in Harris County, Texas, officer observed the vehicle made an improper turn, nearly causing an accident with the vehicle turning next to him by turning into the wrong lane. Defendant then traveled at 80 miles per hour in a 50-mile-per-hour zone and made an unsafe lane change while speeding. Also, I watched the video for this one, so I can answer questions on what actually was observed or what I observed.
So let's break it.
Complaint, it basically alleges unsafe lane change. It doesn't really.
Is that the basis for the reckless driving, the unsafe lane change?
So when the charging instrument reads is essentially in word for word is a reckless driving vehicle with willful and wanton disregard for safety of persons and property by driving more than 35 miles per hour over the posted speed limit, making unsafe lane changes, causing other drivers to have to take evasive action and avoid collision with the defendant's vehicle.
Is that what you saw?
As I did not observe any vehicles having to take evasive action. What I observed specifically was the defendant coming out of the parking lot on Theater Road. He does cut across 3 lanes to go to the far lane. But I didn't see any vehicles having to take evasive action, slam the brakes on. In terms of speeding, I'm not sure if he was speeding or not, but it did look consistent with the flow of traffic with the exception of passing other vehicles.
Coronado?
That's,
I'm going to admonish you.
I think that's very right.
Come on. Who is it again?
This right here is
Mr.
the turning
Deshaun.
point of the entire case, and it's a perfect example of how critical details can make or break a charge. The original accusation paints a picture of dangerous, reckless behavior, speeding, unsafe lane changes, and forcing other drivers to react. But when the officer actually testifies, that narrative starts to fall apart. No evasive action, no clear proof of excessive speed, just a driver moving through traffic, maybe aggressively, but not necessarily criminally. And that distinction matters. In court, it's not about what could have happened. It's about what can be proven beyond a reasonable doubt. So now the question shifts to you. Do you think this driver got lucky, or was the charge simply too exaggerated from the start? But because moments like this highlight a bigger issue. How often are cases built on assumptions rather than solid evidence? And more importantly, how many people don't get this kind of careful review?
Do you watch the news?
Yes, sir.
Do you really? Do you really watch the news? Every single day in our county, someone dies because of a boneheaded move that's made in a car. Every single day, not just one, multiple lives are taken on our streets just because people drive in such a manner that they end up killing someone. You know, yours is not the worst, and I'm going to find no probable cause, but be safe. You know, we're not asking for much. Don't drive unless you have a license. Don't drive unless you have car insurance. I tell you, I get so many emails every week because people, how can you help me? Because I have someone that's suing me for $50,000 because I got into an accident and crashed and I broke their car. They literally ask me to represent them and help them because they don't know where to go to, where to turn because someone filed a lawsuit against them. If someone does that and you get a judgment against you, you're hosed. Get car insurance. And when you drive, do it in a manner that you're not going to injure or kill someone. We're not asking for much. All right.
We had a conversation about that already, Judge.
Be safe. It's not much. You know, if you got to get somewhere in a hurry, leave early. All right. All right. I'm going to find no problem causing your case. All right. Take care, man. Be safe. If I see you back, it's not going to go. All right. Well, please.
Thank you, Judge.
Thanks, Alex.